I don't have $20,000. Just, I mean, I have like, you know, $50 till I get paid on 15th. So, I mean, it's just going to put me in debt. Just, I mean, I don't think I should have to pay him $20,000 when I've been financially supporting my daughters this whole time. He makes three times as much money as I do. And all of a sudden, he wants child support, and that's fine, but I don't have the means to pay him 19,000 whatever dollars just because they want to go back when our son turned 18.
I have this for child support. Declaration affidavit that was filed by Miss Olson on the 27th of February, indicating that she attached an updated child support order and Washington child support worksheet via the Division of Child Support's website. And that's index number 86, Mr. Baldwin, if you're in Odyssey. Nothing was attached to that except for Exhibit A, which was a pay stub. I get my orders for today's docket, and in the orders for today's docket are the child support order and child support worksheets that I'm assuming Miss Olson alluded to. So I have not reviewed those. That's what I wanted you to know before we get started. So I don't think that that's Miss Olson's fault. I just wanted both parties to know that I didn't have an opportunity to review those prior to a quick review this afternoon. So, okay, Mr. Baldwin, where are we at?
Well, so this case had various other parts. Your Honor may recall, originally heard a couple of weeks ago in front of Commissioner Carmi. Everything was resolved beside the child support. Ms. Olson filed a motion regarding child support. The issue is before the court involving an original temporary order from December of 2019 up to what is ostensibly addressing a modification of support based on some additional information. It's Ms. Olson's motion, so I'll defer to the court in what order we proceed.
And that's the child support's the last remaining issue at this point. Is that correct?
It is, Your Honor. There's an issue of retroactivity. Your Honor can see from our declarations. For the court's information, maybe to help with some of the scope, the December 16, 2019 child support order was based in a period of time where there were 3 children of the marriage that were subject to the temporary order. A son who was residing with the mother, and then 2 daughters who were residing with my client. The child support order at that time resulted in a transfer payment by my client, even though he had 2 of the children, because his income was greater, of a couple $100s a month. In July of 22, that son aged out, effectively turning 18, resulting in no more offsetting obligation for support. But because the manner in which the order was written, it did not create anything actionable for support enforcement to enforce any support obligation against the mother, even though there was a child support worksheet and order reflecting support for the girls in my client's care. She, before we were able to effectively made the motion to address support as indicated in her motion, because she wanted it to be clear that she was willing to pay support. And that brings us to where we are today. In addition to the worksheet that was attached to the 27th filing, there are a couple other worksheets that had been filed by Ms. Olson that I'm prepared to address in our argument. But I think the issue is what would be the court's ruling on the basis for the retroactive support to the point at which the son aged out and only the daughters were remaining. And then as far as the new income values, what is support moving forward on the motion that was filed in September?
When did the son age out?
I believe it was July 20th.
June 14th.
June 14th.
June 14th is his birthday.
Of this year?
Of 22, Your Honor.
So a year and a half ago, approximately.
Yes, Your Honor. My staff, when they did the back pay, I think went to the following month. July 20th is what was in our proposed order from our original filings and child support worksheet. So we set it from the next month.
Any comments that you would like to provide?
Well, my comments are in my declaration, basically stating that I feel like I shouldn't have to pay him that back support because I've been supporting our daughters this whole time. It hasn't been going to Mr. Olson's bank account, but I've provided, an example of the in-kind support that everything that I've bought them in the last 6 months. So I feel like I have been supporting them. He doesn't owe any money. I just feel like I shouldn't, just because Justin turned 18, he is not asking for child support until this last August. So, I mean, I don't have $20,000. Just, I mean, I have like, you know, $50 till I get paid on 15th. So, I mean, it's just going to put me in debt. Just, I mean, I don't think I should have to pay him $20,000 when I've been financially supporting my daughters this whole time. I mean, I take out a loan every, summer to get them school clothes. I mean, I buy them, their expensive shoes. And I mean, I do whatever I can for them. He makes 3 times as much money as I do. And, he we agreed that they would go stay there because he has more room and he's more financially stable. So that was an agreement between the both of us. And so all of a sudden he wants child support, and that's fine, but I don't have the means to pay him 19,000 whatever dollars just because they want to go back when our son turned 18. That's not fair to me when I've been supporting them financially in whatever I can, wherever I can.
And are we still pending trial on a final parenting plan?
Yes, Your Honor. The court 2 weeks ago basically made no change to the temporary. Mother hasn't put the matter on. What I'll say is was addressed at least somewhat when we were in court previously. And this all came about with the mother's filing because my client had a letter sent to her. There's a contempt finding by the court because she unilaterally took one of the girls for tax filing, despite the current temporary order prohibiting that, giving the tax filings to my client. We would love to have an agreed resolution and finalize. We don't have that at this particular point, so there is still just a temporary. As to the arrears or the back pay, I've done the math. I mean, the amount by my count is anywhere between roughly $6,000 and $16,000 based on whether the court sets it at the amount at the time of the support order with the incomes and the obligation from December of 2019, or whether the court sets based on the current amount, how far back. I can give the court some more detail if Your Honor would like at this point. But
on the arrearage?
Yes, Your Honor.
Sure, go ahead.
So looking at the child support worksheet that was part of the order in 2019, the worksheet showed a base child support amount for each child of $727. Even if it's kind of, say, nebulous, but if you were to take that amount as set and only have the 2 remaining daughters at mom's 24%, that's about $360 a month. I think it actually would be a little bit higher because the base support obligation would only be for 2 children, not 3. But at $360 a month from July to present, it's right around $6,000. I believe at the most, it would be looking at the amount in our proposed order initially of 16,000. But there absolutely should be, at the minimum, based on the amount set, the base child support obligation for the children and mom's percentage be a arrearage basically for the amount she should have been paying once their son was no longer creating the offset to whatever point the court sets the new obligation amount based on the additional financial information. Mom, at the time she brought the motion in September, identified income of $25 an hour. The twice filed proposed child support worksheets based on that amount. In the new filing, which the worksheet was separated, her income went down because she's working a new job, $20 an hour, with no indication as to why she's taking a job with less pay than she was at the time that she initially filed the pleadings. We ran our worksheet based on our client's actual income and the $25 an hour she'd indicated she worked, and came out to the support obligation a little over $1,000 a month. Again, I can go into sort of detail on each of those, but I realize Your Honor just said on the arrears, so I'll stop and give a moment there.
And the last judge said that amount was so high, that's why we're here today. and you keep bringing up the contempt and everything, and that was resolved 2 weeks ago. We're here for the child support. I do make $20 an hour. It was by no choice of mine. And that's,
So between
yeah.
September 20th of this year and today, you've been cut $5 an hour in pay.
Yes, I started a new job. I left my job on October 17th and started this new job November 6th. And my question is, like I said, I don't have an issue with, supporting our daughters, but when our son aged out, why didn't Chris ask for support? I mean, why do they get to go back now when I am the poorest I've ever been?
Well, I can't give you legal advice, but that is something that the court can definitely consider. So are you at A&D Auto Sales?
Yes.
And you started that
November 6th. I guess that's the technical name. It's Allen Webb Auto Group.
So I do see the earnings statement that was submitted. So your calculation based on that new employment, Miss Olson, is the $34.67 a month. Is that correct?
What did you say? I'm sorry, you cut out.
$34.67 a month is what you're estimating
Yes.
your gross monthly income.
Yeah. Yes.
All right. And Mr. Baldwin, your client's gross monthly is shown at, hold on here.
Our gross was
97.23.
23. Yes, Your Honor, and a net of 59.73, based on his pay stub that was filed October 10th, showing his federal income taxes, Social Security, and mandatory professional dues. But also, I guess, Your Honor, I can respond briefly at least to one piece. I believe my client's declaration reflected he had attempted to go through child support enforcement to enforce the support after their son aged out. But because the child support order specifically stated the obligation on him and didn't account for a scenario where there was no longer the offsetting, they couldn't help without bringing it to court. What ended up happening was a letter was sent to try and negotiate a resolution. And in lieu of that, she filed her initial pleadings in court. And that's where we are today. As to
he tried to go
Hold
in
on,
June.
Miss Olson, hold on.
As to income, I guess a couple of things are concerning. When we were in court, there was an objection filed to strike a pleading from Miss Olson that was filed October 30th because it was filed late in time. It wasn't considered for the hearing. We were set over it to today so she could refile regarding her child support. Though it's not probably considered as something substantive for Miss Olson. On October 30th, almost 2 weeks after she said she lost her job at $25 an hour, she had filed the child support worksheet showing her gross income at $4,000. And I do find that somewhat concerning. I point that out only because in her prior filings, she has been very scattershot in what she has my client's income as. Her initial motion for support had him at a gross of $14,000 a month. We filed with a gross of $97.23 off of his pay stub, resulting in the net of $59.73. Her filing on October 30th had his gross at $97.29, very close in line with what we had, and a net of $59.66. And her subsequent filing from the 27th of last week had his gross income $10,540, $1,000 more than her previous filing, and a monthly net of $7,700, and about $2,000 more than her prior filing had shown his net as. We believe that our income for our client is accurate, and the court should set his income based on our proposed gross and net. We certainly have concerns with her income. I will say that I think if the court were to take 40 hours a week at $20 an hour, the amount for her income as stated in her worksheet from the 27th, with a gross of around $3,500 is relatively close, if not accurate, for a full-time job at $20 an hour. But given that her other filings subsequent to the identified loss of the employment shows $4,000 or $4,300 we'd ask the court to set her income at 4,000 gross and 3,400 net.
So I have a question. So, well, it's a statement and a question. So the reason why my first one was so high for the respondent is because he tells everyone that he makes $65 an hour. So I didn't know that his actual, that's none of my business what he makes, but that's what he, tells people is that he makes $65 an hour. And so I didn't really know that he made 6081 until, I received those documentation from the papers. And so I left that I made that because things don't seem to be going my way anyhow. But then when the judge 2 weeks ago said for me to redo them, I redid them at what I am currently making. So it wasn't to be malicious or anything like that, or I make $20 an hour. And so she asked me to redo them because that's why we're here. We didn't rule on it 2 weeks ago because she said that his is substantially higher than mine. And we're supposed to be going off of gross. He works a ton of overtime, a ton of double time. That doesn't get counted. So I'm not sure why we get to flip flop that, his gross is this, but he only nets this. Do you want to see my net? Nobody's asking for my net. Like I said, I can barely make it to the grocery store.
Well, your net is provided on the worksheet. So your net is 2917.
I understand that, but I'm saying it's like they want to act like he doesn't make 3 times more than me. And he's well off.
All right. I'm going to adopt Miss Olson's 3467 as her gross. And I'm going to adopt his gross at the 9723, which puts his net at 5973 and her net at 2917. I know that standard calculation is going to be different than either one of you proposed. And I also know that there was a credit that, at least in Miss Olson's proposed, that she assigned herself based on cell phone payment for one of the children. And I don't know if that's agreed that she pays that, and frankly don't know if it's appropriate for it to be part of the child support credits. It's something the court would consider if that's agreed upon.
And I can say, Your Honor, it's not agreed for that to be a credit. We did also have in our proposed worksheet, my client's declaration, 1,200 additional income to her on my client's information and his declaration that 2 adult sons who reside with her pay $600 a month each in rent to her. I didn't see anything in her declaration refuting that. So that was part of the additional difference in our proposed worksheet from what her gross income was and her net being technically higher after deductions because of that additional income.
I do see that in other income on your October 10th proposed child support worksheet. Ms. Olson, do you receive supplemental income for rent from anyone?
So we split the bills 3 ways. I don't pocket that money. They help pay towards the PUD, towards our space rent. They help pay the Wi-Fi because they all use it. So I'm not getting that extra. It all goes to bills. And the last judge 2 weeks ago said, I don't know why he keeps bringing this up.
Because I need to know all the information, ma'am. Okay. It doesn't matter what the judge 2 weeks ago did. I'm the one deciding this right now. Okay. So if you that's all I need to know. So if you pocket it, then
yes,
$100.
I get $177 extra dollars from each of my sons a month.
So you do pocket some money. It doesn't all.
No, they give me $177 each. There's 2 of them, and it all goes towards bills.
Okay.
Every single dollar of it.
Okay. All right. So I'm not gonna add that to her tally, Mr. Baldwin, and I'm also not gonna add the $100 mobile phone expense. So I don't know if we can run the worksheets based on those numbers. That's the support that the court would be ordering.
Okay. And effective what date, Your Honor?
At this point, I'm going to say effective November 1st. I'm going to reserve on arrearages for trial. I think there's more information that the court needs to really make that decision. So I'm not gonna, so what that means, Miss Olson, is I'm not ordering arrearages for you to pay any arrearages at this point. However, that means that once we get to trial, if they are wanting to ask the court for arrearages, then we would, they would be free to argue for that, and you would be free to argue against that at that time. Do you want to set a presentation date?
Yes, Your Honor, if we could.
How long do you need for that?
1
weeks.
Are you on the docket on the 26th?
Unfortunately, I am. Yes. So
The 26th is the next time I would be here, Your Honor. So.
All right, Miss Olson, are you available the 26th at 1 p.m.?
I mean, I believe so. I thought it was all over after today.
Well, it all we need to do is enter the final order, because I adopted some of your numbers and some of his numbers, so we have to kind of do a calculation. If I will say this, if Mr. Baldwin runs the orders, you agree with the orders and you sign them, give them to me, I'll sign them, and we don't have to come back on the 26th. Is that fair? Okay.
Yes, thank you.
Thank you, Your Honor.
All right. Thank you. Good luck.
So literally about 2 years after Tyler was born, you did tell me I cheated on you. He's not yours. You've told me that at least 5 to 6 times. So when you said that, that was a lie. You've told me many times that he's not mine. Out of spite, out of anger, I don't know what it's
Objection, he's testifying. That's not a question.
Mr. Thompson,
Is
have you told
me that he's not my that I am not the father?